Greetings to you, ladies and gentlemen, and welcome to our new lesson entitled Law of Civil Procedure. Law of Civil Procedure forms part and parcel of the curriculum. Introduction to law is one of the most important areas of law. You will remember that we spoke of the different classifications of law, and we said that civil procedure in particular falls under the ambit of private law because it consists of litigation that is in between two persons. So this is exactly what we're going to be talking about today, and I trust that you will find the lesson interesting and enjoyable. And remember that most of the things that we're doing are examinable, so it is in your interest to study, to learn, and when you have questions and things that you do not understand, you consult me. So we're going to be looking at the nature and the scope of civil procedure. Okay, so generally the law, or our law, gives a citizen certain rights and remedies. You will remember we spoke about the rights that an individual possesses in terms of law, the rights of being capable to sue and to being sued, which applies to a natural person, also applying to a juristic person as well. Right? So if one of those rights that are granted by the law is infringed, the aggrieved person, which is lo mntu lona ke oye kwenzeke into ba alimale okanye enzwe kakubi as a result of ukuviolate kwezo rights, can enforce his rights through the court system. In other words, the rules of civil procedure again are concerned with the manner in which an aggrieved party may bring his case before the appropriate court for an authoritative decision that is enforced by the state. So apha ke, ladies and gentlemen, sithetha ngomntu onwe ngomnye umntu, into kokuba angafumana kanjani ke into kokuba afumane iremedy as a result of ukuxhatshazwa ngomnye umntu, as a result of ukulimala kwakhe. And ke civil procedure is mostly concerned about exactly that, about imithetho that have to do with procedures. In other words, how do you bring your case before a court of law if your rights have been infringed by another party? You'll recall that this is quite distinctive to the criminal law, where we used to say that where there had been violation of your rights that involve you being assaulted, you being raped, etc., it falls within the ambits of a state. Now we're looking at your personal interest, okay? Because when a criminal matter is committed against you, you are no longer litigating, or you're no longer protecting yourself, but you are protected by the state itself, which is how it's different again to a civil procedure. In a matter involving a dispute, the issue first to be determined is whether the aggrieved party has a right, and if so, whether that right has been infringed. Okay, so in other words, let us look at imoto yakho uthi uchayisiwe, and then you want to claim it damages. So siyalungela uba unalo na ilungelo ke ngoku lokuclaima against le moto lena echayisiweyo. In other words, do you have a right? Is this car yours? So uzawuclaima nje into ba ufuna ilungiso. And then if so, xa uchayisiwe, is there a right that has been infringed? Of course there is a right that has been infringed, because you have a right to drive and be able to utilize that car, but HSO you cannot do that. So a right has been infringed in case of a motor vehicle. So if a right has been infringed, then it follows that the injured party does have a remedy, because this is a general rule that there is a right, or rather where there is a right, there is a remedy. Ubi ius ibi remedias. Okay, so apho ke kukho khona ilungelo, then kukhona ke nokubuyekezwa, which is a remedy. So in summary, in law of civil procedure, we're looking at really the procedure that one applies to go to court when his or her rights has been infringed, especially where a right exists, right, and whether a right has been really infringed. Are we together? So the next step therefore would be to determine which court is competent to grant the remedy. You will remember, ladies and gentlemen, we did speak about jurisdiction. I think after we had dealt with the sources of law, we spoke about the hierarchy of the court. We mentioned the fact that there are different types of courts and the circumstances that you can go to those courts. So civil procedure is eyona ndawo apho kubaluleke khona into kokuba uyazi uba yeyiphi le nkundla uya kuyo. Sizawujonga loo nto ke ngoku xa sithetha nge-jurisdiction, sithetha ngento yoba based on a right that has been violated, which court will I be able to go to? That is what we're talking about xa sithi jurisdiction, because awukwazi ukuya nakweyiphi na inkundla ngenxa yento yoba uthi a right has been violated. You cannot just go into any other court. So this involves the issue of jurisdiction. By jurisdiction is basically meant the competency of the court to hear an issue and give authoritative. We hear the keyword is competency. That particular court must be competent enough. In other words, I said competent, as starting a competition, but we speak about the issue whether that court has the authority. Is it competent enough to hear that matter? The issue of jurisdiction is addressed before the commencement of proceedings, and the selection of a competent court in turn influences the nature and the conduct of the proceedings, right? So even before we go to court, even before we issue summons, we must be able to determine which court has jurisdiction to hear this matter, and it must be addressed accordingly, because it is it that is going to determine the nature and the conduct. In other words, each court has its own civil proceedings. Each court is governed by its own rules, right? So you cannot, what you are able to do in the magistrate court, be able to do in the high court, because it has its own rules that is governing each court. So the major courts with civil jurisdiction in South Africa are the following. It is the Supreme Court of Appeal, the second highest court in the land. We have the high courts, and we have the magistrate courts, consisting of the district magistrate courts and the regional magistrate court, which are 62 around the country. Are we together? So the conduct of proceedings in each of the court, as I said, is different. Although there are similarities in many respects between the high court and the magistrate court procedure. As of the 15th of October, the magistrate court procedures were amended to being the procedures in line with the high court procedure. So the only distinguishing issue, therefore, between the magistrate court and the high court would be their ability to hear certain matters, and we're going to be putting them into bear as to what determines whether the magistrate court or is the high court that has competency and jurisdiction to hear that particular matters. Although the rules were brought in line, they might not be the same, because at times the high court has an inherent jurisdiction. In other words, it can be able to hear any other matter. And in addition to that, it may be able to also really create its own rules and proceedings. The magistrate cannot be able to do that. It is a creature of statute. It depends upon the statute itself. Whereas the high court can create its own rules, it can be able to regulate its own self, and through its interpretation of decisions, can really almost have a law-making process through its own decisions. But we're going to go into depth about that as we go. So the other distinguishing factor obviously may be a value, because the value that the magistrate can, the matters that the magistrate court can be able to listen to are kept by the various values. So, causes of action. A party must have a legally recognized right, as we have said in the beginning, which has been infringed before legal proceedings can be embarked on in order to enforce that right. Right, we did say this. And then in litigation, this is commonly known as cause of action. In other words, a party must have a legally recognized cause of action or reason for the cause of action he wishes to take. So that violation of that right, ladies and gentlemen, we call it a cause of action. What brings us before this honorable court is a cause of action. We do not say that a right has been violated, but we say it is a cause of action that brought us here. So we're going to be looking at the causes of action which frequently arise and have to be dealt with in practice. For example, when we talk about practice, we talk about attorneys who are practicing in attorneys, operating various law firms and taking various matters to court. Goods, firstly, being number one, goods sold and delivered. Okay? Goods sold and delivered. So the issue that may arise there may be you having had purchased certain goods, let's say for example from Take a Lot or from a certain company, and you require them to deliver them, right? Let's say that then that delivery did not take place in terms of the agreement, or that delivery took place but it is defective. So a cause of action therefore has arisen there, because you were supposed to have received those goods but you do not receive them in terms of the initial agreement. So you can take that matter before an honorable court of law, depending on the value, and also insofar as it concerns delivery. Okay, where a thing had been delivered to you and the agreement was that you would pay on arrival, and you do not pay, and you all of a sudden say you do not need that product anymore. Obviously there could be a cause of action that would arise from that matter, because you had initially agreed there had been petrol expenses that had been paid for it to be there. The goods have been removed. So immediately they usually hear that the minute Imoti Pume Garage, if value has decreased. So those are other considerations that need to be taken. Work done and materials supplied. Work done and materials supplied. Professional services rendered. When we speak about professional services rendered, we speak about your lawyers, attorneys, your advocates, the fees that they generate as a result of having represented you in court. You are required to pay certain fees, disburse certain fees as a result of the fees, including the doctors themselves. We call them professional service fees rendered, even in terms of the audit fees that are undertaken by accounting firms, auditing firms. Those are professional fees rendered. If you do not pay those fees, a cause of action has arisen. Professional services rendered and disbursements, money lent and advanced, that is where you are lent money either by the bank or a person who is, in terms of the National Credit Act, authorized to lend money. You can be able to do so and bring a cause of action if that person doesn't bring about money. Dishonored checks, know what a dishonored check is. We present a check for payment and then you find that there is no money in the bank. Obviously that system, I think, is gradually being wiped out, if it has not been wiped out already. Acknowledgements of debts, motor collisions, overpayment, installment, sale agreement, okay, where perhaps you become in mora in default of a certain payment, so you therefore become liable in that case. Are we together? So how do we then, because remember we spoke about each jurisdiction previously. We said that its jurisdiction is whether that court has the competency and the authority to hear that matter based on different factors. We spoke about the different courts and what have you. But now we're going to be looking at the determination of exactly how that jurisdiction is determined. Once it has been ascertained that a party has a cause of action, which we spoke about previously, it must be established in which court to institute the claim. Various factors play a role in a client's decision whether to sue in the magistrate courts, which could be the district or the regional, or in the high court. So the following factors are important considerations in determining which court to institute an action. Whether the magistrate court, district or regional, has the jurisdiction to hear the matter based on the costs. In other words, how much will it cost? We are talking about your own considerations now. Based on costs, how much will it cost to bring about that application? We look at the tariffs. The tariffs are already prescribed by the rules of the court as to how much an attorney is allowed to charge in the magistrate court, how much an attorney is allowed to charge in the high court, speed and urgency. So that one would be based on the influx of cases that are brought before a court of law, right? When we talk about speed, it is determined about the influx of cases that are brought. So ordinarily, if you look at the high court and the magistrate, you would find that at least the magistrate, because inkundla efikelelekayo iyo mhlawumbe ke engafika ithathe ixesha because of a number of matters that have been instituted there. So it will then determine the speed and the urgency, right? And then the convenience, which one is more convenient for you, the complexity of the matter. There are certain matters that obviously, as we're going to be discussing, you'll hear that they are so complex that they cannot be heard at the magistrate court. The importance of the case to the client and the quality of the justice dispensed. All right. So let us look at the matters that are beyond the jurisdiction of the magistrate court in terms of section 46. In terms of section 46, in other words, we're going to be talking about matters that the magistrate cannot be able to hear general, right? The magistrate is prohibited from hearing these matters in terms of section 46. So that even before you determine that jurisdiction, you may be aware that those one are a no zone. Certain matters are beyond the jurisdiction of the magistrate courts, regardless of the amount or the value of the claim. Magistrate courts do not have a jurisdiction to hear the following type of matters. Matters in which the validity or interpretation of a will or other testamentary document are in question. Right? This one is very important, ladies and gentlemen, especially for those who are inquisitive enough to be aware, or rather to listen to the news of the current state of affairs in the country. You'll recall that the king of the Zulu people had died, right? And then in terms of the will of the king, the queen had been appointed to be the interim queen. And then after the queen had died, the King Mrs. Zulu became the subsequent king of that nation. But then, the other parties or another litigant within the same house brought a challenge before the Kungundlovu, Pietermaritzburg High Court to really challenge the validity of the will that said King Mrs. Zulu could be the heir to the throne after the queen. They are challenging the validity of the signature. They contend that the signature of King Zwelithini might not have been his signature. In other words, there's a possibility that they are saying it could have been forged. So if that, ladies and gentlemen, therefore is a dispute, it is a matter that can be brought before, because the cause of action has arisen there. But now section 46 of the Magistrate Court rules or Magistrate Court Act prohibits the Magistrate Court from hearing such matters. Hence it was heard directly at the Pietermaritzburg High Court and not at the Magistrate Court, because there are matters that are specifically excluded from being heard. Secondly, matters in which the status of a person with respect to mental capacity sought to be affected, right? So there are people, ladies and gentlemen, who generally, insofar as it concerns their mental capacity, the determination still has to be heard. And as a result of that, a curator, Bonaris, may have to be appointed so that that person acts on behalf of that particular person. For example, in a matter of road accident fund, where a litigant is a person who must be involved in a car accident, and that person injures his head, injures his mind, then that particular person, in all respect, may not be able to litigate on his own. A curator, what is called a curator, will have to be appointed to act on his behalf. So that particular application to appoint that particular curator will then have to be made in the High Court. Okay, so it is specifically excluded in terms of Section 46. Matters in which the plaintiff seeks specific performance without an alternative payment of damages. You remember we spoke in the law of contract and said the remedies that are available where there is a breach of agreement may be to seek specific performance or payment of damages. So there may be circumstances where you do not want an alternative, which is the payment of damages, but you seek a specific performance to that contract, that in terms of this contract you had agreed that you will deliver A, B and C to me. You are the only person who can be able to deliver A, B and C. I don't want any payment of damages because I cannot get this from any other person but you, right? So as a result of that, I do not want an alternative which could be payment of damages, but I want the court to direct you to pay specific performance. Okay, so that is what then happens in that particular case. Matters in which a decree of perpetual silence are sought. Therefore, these cases will have to be instituted in a High Court. Are we together? Jurisdiction in respect of causes of action. We're going to be looking at those now that it has jurisdiction over. The list is not exhaustive, but we're going to be just mentioning just a few of them. So once you have determined that the type of case is not beyond, because Section 46 clearly stipulates that this and that is not within the scope of this particular court, is not beyond the jurisdiction of the magistrate courts in general, you will establish whether the magistrate court has jurisdiction in terms of Section 29. Section 29 deals with the cause of action and the value of the claim. The cause of action which are within the jurisdiction of the magistrate court in Section 29 are actions which is claimed the delivery or transfer of any property, movable or immovable, not exceeding in value. All right, actions in which is claimed the delivery or transfer of any property, movable or immovable, not exceeding in value. So the cap for the magistrate court is up to 400,000. So that cap being up to 400,000, ladies and gentlemen, it means that for a delivery of a good or for a transfer of a property, that speaks to the sale of a house. If, for example, a conveyancer facilitates the transfer of a certain property and you obtain a title deed, but there is a dispute with regard to the delivery of this particular property, if an action would arise, as long as it does not exceed the value which is determined by the Minister of Justice from time to time, then it can be heard. Dispute or the delivery of a specific thing, dispute, then it means that it can be brought to be challenged before a court of law. Actions for a judgment against the occupier of any premises or land within the district, regional, provided that where the rights against the occupier of any premises or land is in dispute between the parties, such right does not exceed in clear value to the occupier. So here we speak about, when we talk about injectment, it may speak about, more importantly, eviction applications. You being able to evict someone from a particular property. The magistrate court does have jurisdiction to entertain that particular application. Okay, and provided that obviously where the right against the occupier of any premises is in dispute between the parties does not exceed the value which we spoke about, that can be determined by the minister from time to time. Right? Actions to determine a right of way, the value of such is not relevant in this particular case. Right? So actions to determine who could be the rightful owner, who could be the rightful possessor of a thing, value is not really important there. Okay? Actions on or arising out of a liquid document. Considering a liquid document, we speak about where really it is insofar as it concerns a check, right? It is a check or a contractual agreement that speak to a money value, right? That is what we spoke about when we talk about a liquid document. In other words, it can be ascertained in terms of a value, right? Or a mortgage bond where the claim does not exceed. Another example of a liquid document is an acknowledgement of debt, right? We do not need to prove anything there. It exists. We simply take it to court and we litigate. Mortgage bond, sale of a house, even then. Where the claim does not exceed, actions on or arising out of any credit agreement as defined in Section 1 of the National Credit Act. If you have entered into a credit agreement with any clothing store, with any car, motor vehicle finance, in terms of the National Credit Act, then it does have jurisdiction to hear that particular matter. Right? Parties to litigant. So, parties to litigant, we speak about abantu abakwazi ukuza enkundleni. Remember that no Tom, Dick and Harry is able to present him or herself before a court of law. Not just anyone is able to represent him or herself, whether by an attorney or on his own legal capacity. The usual action procedure involves a plaintiff and a defendant. In other words, plaintiff and defendant. So the first thing that I should have told you is that the reference to these things, sinomangali, sibe nomangalelwa. Are we together? Sinomangali, sibe nomangalelwa. Okay? So umangali ngu plaintiff, ngulo ozomangala, and then the defendant ngulo ozosthethelela umangalelwa. Are we together? This basic principle has been extended to include other persons as parties to an action. The rules make provisions for the joinder of a person as plaintiff or defendant, the intervention of a person as a plaintiff or defendant, and the substitution of parties. So what we are simply saying there is that litigation, more especially against companies, what we call class actions, is not necessarily confined to one person. If, for example, you worked for a mine, and then for subsequent reason, some reason you become sick and you discover that I am worth a local up lung disease and niyabhubha. So the families can institute a class action. And not a class action on behalf of the deceased parties, because they would be aggrieved. So they would be known as the plaintiffs in a class action. In other words, they won't have to be enlisted as a plaintiffs against this gold mining company. Right? So what is being looked at Keglo plaintiff law? Number one, the capacity to participate in legal proceedings is described by the phrase locus standi in iudicio and can be summarized as the right to be sued or sue. A minor under the 7 years, or rather under the age of 7 years old, has no locus standi in iudicio, and the proceedings should be brought by or against his or her guardian in his capacity as such. So umntwana onaphansi kweminyaka eyi7 iyazivakalela, awunawukwazi ukumzisa kwinkundla zamatyala, kufuneka amelwe yi-guardian. In other words, akamela nokumela i-guardian, they are brought against his guardian. Okay, if umosha umntwana wakho na 5 years old, you are going to be liable in your capacity as such, because lo mntu lowo does not have the necessary mental capacity to appreciate the consequence of his actions. If a minor is between 7 years and 18 years, the guardian must assist, right? So if the minor is between 7 years and 18 years, then you can have a guardian on a representative capacity. Now remember, under the age of 7, we said in your own personal capacity, but between the ages of 7 and 18, it is on the assistance. So in other words, you can also be found guilty if you are between those ages and be taken to a court of law, but you own a representative guardian. Legal representation. Every natural person who is a party to legal proceedings is entitled to represent himself in person before a court. It is, however, common practice for a party to litigate and appoint an attorney to act as his or her representative for the purpose of conducting the suit. So you are in your own personal capacity able to represent yourself in court, your mangala, as long as you'll be able to do everything in terms of the rules of the court, because you must remember that there are rules that are prescribed before each and every court that must be followed. Also value nje nkundleni uthi hey lo muntu undichayisile lo intervene. No, there are certain rules, there are certain standards, there are certain procedures, there are certain papers that need to be filed within specific time frames, yada yada. So it would be really in your interest to be able to appoint an attorney so that you can be able to do that. Adequate notice. It is a cardinal rule of South African level civil procedure that the opposite party be given adequate notice of processes and proceedings and should be afforded an opportunity to present its own side of the matter. The well-known Latin maxim of audi alteram partem refers this to the rule of natural justice. This, ladies and gentlemen, means in a nutshell that if you are going to institute an action against another person, uzomangalela umuntu as the plaintiff to the defendant, the principle of natural justice audi alteram partem means that that other party must be given an opportunity to hear the case that is brought against him. Not only to hear the case that is brought against him, but give him or her an adequate opportunity or chance to be able to adequately respond to elityala, because kusanakwenzeka into kokuba hayi man lo muntu kavela ngawuchayisa lo wena ungene kwilane yakhe, so funeka kwazi ngokubeka and adduce his or her own evidence before a court of law and be able to place on record his or her side of the story and not just hear his one part, right? Must be able to hear both sides of the story. So that is the principle of audi alteram partem, which is the rule of natural justice. Service of a summons by the sheriff on the defendant not only commences proceedings but also gives notice to the effect to the defendant. If the defendant decides to contest the matter, all further pleadings and notices in the case must be served on the either party or his agents, that is his attorneys, right? So when the summons have been issued, when the summons have been commenced, zakucho, which set out the cause of action, which set out the matter that you are bringing before the court of law, they commence the legal proceedings, right? And then they give notice to the ummangalelo so that azokwazi ukucontesta as defender. The manner in which a summons is or is the manner in which someone is serviced is regulated, every someone must also stipulate the prescribed period, known as dies inducae, within the defendant must answer the stated in the summons. Judgment may by default be granted against the defendant only after the time has expired within which he is permitted to deliver his notice of intention to defend but the action but has failed to do so. That's where I said to you, ladies and gentlemen, it is in your best interest to appoint an attorney, because as a lay person who is doing his or her own things, you may not be aware of the fact that there are time frames to all of these things. There are time frames, right? There are time frames which are prescribed to all of these things. So it becomes important for you then to appoint an attorney, someone who's going to take cognizance of these issues. Otherwise, if you don't meet these time frames, then you are out of time and you may have to seek condonation, and also if you don't seek condonation, a default judgment may be sought against you, or an order for an absolution of instance may be sought against you as well. Not only must adequate notice of the commencement of proceedings be given to the defendant, adequate notice of the nature of an opponent's case must be given so that the party concerned may prepare adequately to meet it and not be taken by surprise at a trial. This is achieved by the exchange of pleadings. Other procedural mechanisms, for example, medical examinations, inspection in loco, and the discovery and the inspection of documents also serve to enforce this principle. The rule of adequate notice applies equally to action proceedings as well as application proceedings. So as a such discusser for now, we're discussing action proceedings, right? We're going to be discussing application proceedings after action proceedings. So those summons and yada yada are applications. You are in action proceedings. Thereafter, we're talking about applicant. We're talking about plaintiff and defendant. And then when we talk about application, we're going to be talking about applicant and a respondent.